We'll do the vote for Andrews' bill after.
Are there extra copies?
We'll do Devendorf first. So.
Okay.
The Economic Development and Small Business Subcommittee on Housing will come to order. Will the clerk please take attendance?
Chair Coleman.
Here.
Rep. Devendorf. Here. Representative Stone. Here. Representative Scott. Here. Representative Andrews.
Here.
Representative Grant. Representative Cernoglu. Here. Representative Aragona.
Here.
Representative Zorn.
Here.
Representative Fink.
Here.
Representative DeBoyer.
Here.
Mr. Chair, you have 10 members present. You have a quorum.
Thank you. Representative Andrews moves to adopt the minutes from the meeting on September 28th. The meeting minutes from September 28th are adopted. First, we will take a vote on Rep. Andrews' bill, House Bill 4891. Representative Scott makes a motion to refer HB 4891 to the Committee on Economic Development and Small Business. Madam Clerk, please take a roll call.
Chair Coleman.
Yes.
Representative Devendorf.
Yes.
Stone.
Yes.
Scott.
Yes.
Andrews.
Yes.
Grant. Cernoglu.
Yes.
Oh, Grant's here.
Oh, sorry. Representative Grant.
Yes.
Representative Cernoglu.
Yes.
Representative Aragona.
No.
Representative Zorn.
No.
Representative Fink.
No.
Representative DeBoyer.
No.
Mr. Chair, you have 7 yeas, 4 nays. The bill is referred.
Thank you. House Bill 4891 is referred back to Chair Hoskins and the Economic Development and Small Business Committee. Next, last week I let our Vice Chair, Rep. Devendorf, know that we would give her a little more time to talk about the Homeless Bill of Rights bill. So you can take a few more minutes, Rep. Devendorf.
Thank you, Chair. I'm going to start out today just doing a quick overview of the legislation, giving a few clear examples of what I have witnessed or experienced over the last year or so through my direct service and relationship building. And I'm going to make that very quick so that we can let any folks who need to finish their own storytelling come up and finish their testimony, and then I'll be open for questions. I did hand out to you today, in order to answer some of the questions from last week, some of the best practices on homeless encampments and how to truly get to the root of homelessness, to show that best practices say that what we should be doing is to be bringing wraparound services to the folks that are struggling, and that moving folks from a place where they are rooted or have set up camp really just adds to trauma and exacerbates the social determinants of homelessness. The Homeless Bill of Rights ensures that there are equal rights and privileges and access to public services regardless of housing status, real or perceived. It guarantees the right to move freely in public spaces, have equal treatment by state and municipal agencies, freedom from discrimination in employment, right to emergency medical care, if a U.S. citizen, the right to vote and access identification documents, protection from disclosure of private records without authorization, the right to privacy for your own information, and the right to personal property, the right as well as the right to be enrolled in school if you are a homeless youth. A few of the examples I want to show, because we heard a lot of stories, and I think that we really saw the complexity of our housing crisis in the last hearing, but I wanted to give some examples of what I have come to see through my own community service. The first one is the case of somebody who has become a close friend, who came into my bookstore because a DHHS worker had been leaving notes on his door asking him to call, but my friend is deaf and uses ASL and does not use a phone and does not have a home or a permanent address. His shelter address changes, so information from our state agencies don't get to him consistently. We, over time, were able to start to look into obstacles to his housing, and I was able to find a place that finally approved him for his housing, considering he received over $800 a month in Social Security. And we seemed to be almost through the process when they checked his credit, saw that he had 0 credit because he has not had a house or money for years. 0 history of payments because he has not had a shelter or money for years. And therefore could show no pattern of being able to consistently pay bills. And he was denied the housing that we finally found that would be able to help him with all of his accessibility. He also, just in that example, we see language obstacles, we see technology obstacles, we see source of income and credit obstacles, and we will certainly be trying to address those types of things as we look at additional housing legislation after today. But as a reminder, today is creating that bare minimum of establishing a measure of humanity for our unhoused citizens, our residents. The second example is one that I mentioned just the other day to some of my colleagues, where somebody I know in community had her brother freeze to death in his car just last November. There were many overlapping struggles, and yet no shelter was available to at least alleviate that stress. In addition, I live right downtown, so one of the things that I do and that I've done for years is to, in order to know what's happening in my community, when I hear police sirens and I am able to do it, I will flip on the radio. And a couple years ago, after this legislation was already introduced, it was the middle of the afternoon, and I turned on the radio, and the police were responding to a unhoused gentleman who had been standing outside of the Jimmy John's out on Washington Avenue, and 4 teenagers maced him in his face and then ran away. Last night, somebody sleeping on the train tracks was hit by the train. Hit by the train. So that is where we are with houselessness. Every single district might not be struggling to the same degree, but many are struggling. And today we're talking about how to go beyond just building and looking at how we establish a baseline for how we treat each other in the meantime while we get to addressing all of these different things. Now, if other folks could come up and then we answer questions later, that would be great.
We can have a few people come up, just a couple minutes each, and just introduce yourself and what organization you're with, or if you're just here to speak to the bill. Oh, are these cards? These are for these? Okay. Okay, we do have some cards that we didn't go over last time, so I see these here. So we have William Lawrence from Rennes 2 Dam High.
No comment on this one, just in support.
Okay. Give us just 1 second here. What, Rep, do you have a couple people to bring up? You can just introduce them, that's fine.
If nobody has any additional questions, I think that's fine. We can go on with questions. I just want to leave the opportunity. Okay. I think that we're good to continue.
And if you could do something for us, Vice Chair Devendorf, if
Yeah.
you could just kind of really plainly in a couple sentences, just tell us what the bill does and how would this impact local government or law enforcement? Just give us a couple really clear examples of what.
Yeah.
Because I know you've spoken to the concerns of homeless advocates and people, without housing, but in general, but specifically, what would the bill do and how would it impact the community? Thank you.
Yeah, absolutely. And I did forget an example that I am hearing, that one of our main encampments was actually cleaned up by law enforcement last night and everybody's belongings were thrown away. So this bill just establishes that the rights and opportunities that the average person has be granted to folks regardless of their housing status, which means when we're talking about public spaces, we're talking about the right to move freely on sidewalks, the right to be in parks, the right to have access to Secretary of State and the county clerk and our Social Security office. A lot of these things, while it is assumed they are readily available in part because they're created in order to help our most vulnerable community members, still have their own visceral knee-jerk responses to folks who are unhoused based on stereotypes and assumptions, whether that has to do with assumptions on behavior or dangerousness, or just undesirability. Honestly, one of the main terms that is used on a police radio to talk about when a unhoused person is found, they use terms like undesirable or unwanted. We have a call, and that is what we are calling unhoused folks when they are in spaces that make us uncomfortable. But unfortunately, we know that denying folks those spaces is not getting to the root of it. So this just provides legal recourse should our unhoused community members be denied access to any of our basic services and opportunities, spaces.
Okay. So what is an example of legal recourse? Like what could someone file suit on?
So just as in any kind of civil rights protections or non-discrimination protections, somebody could file a suit if they were arrested because they were on a sidewalk, which happens. If somebody has their belongings stolen or thrown away. If somebody is denied the fast and efficient enrollment in school as a homeless youth. All of these, if it is made difficult or impossible to attain an ID because you can't access the government resources in order to do so. I mean, just any of the examples where somebody could possibly be denied the services and spaces that we all already have access to, a houseless person would be able to file a civil suit. Now, where are the challenges in that? I think that we can guess. If and when this passes, and I say that because I've talked to houseless advocates regularly, and last night just talked to another coalition in Grand Rapids. And when I brought up that we would still need to be doing public education for our unhoused community members on the fact that this new tool exists in order to protect their access to public spaces and resources, the housing advocates said, fine, great, wonderful. We would be happy and excited to go out and make sure that people know that they have this additional protection and right, and to connect folks with legal aid in order to help them to pursue this new protection. Obviously, it would be ideal if we were also helping our houseless advocates or our advocates on houselessness to finance that outreach, but right now they would just be grateful for the tool and be happy to go out and do that extra step.
Thank you, Representative. So just from my perspective, it seems like this kind of focuses around non-discrimination for the most part. There were a few cards that came in, so I do want to just double check that we have. Yeah. Okay, yeah, actually, we'll go to Representative Fink first.
Thank you, Mr. Chair. I kind of want to, Vice Chair Dievendorf, I do want to talk a little bit about some of the details. I mean, so a question, and I know that I think you mentioned last week that probably some of the issues covered here are accounted for elsewhere. For instance, I think it's already equally legal for everybody to move on a sidewalk. My question would be, are you talking about something like sleeping on the sidewalk? Is that I mean, because I think the text of the bill is that moving on the sidewalk, a person can't be restricted from doing that on the same, equal status with every other citizen, which I think we'd agree people already have an equal right to use the sidewalk for movement. Are we talking about uses beyond that?
Yeah, so I would agree and disagree. Why all and any non-discrimination, anti-discrimination policies that we enact, we put into place because we know that while everybody, regardless of who they are, should have access to certain things, that some folks just don't. Some folks are consistently denied access to certain resources and opportunities that everybody else has. If that wasn't the case, we would not have to explicitly say you could not discriminate against this person or based on this reason, based on this reason. Non-discrimination policies come up because despite the fact that sidewalks are public spaces, some people are denied access to them. despite the fact that government services are public services, some people are denied access to them because we're human beings. We have our own hangups, we have our own fears, we have our own biases. We have deemed, unfortunately, through our laws and also our actions, that we have deemed and been treating some folks as worthy of our time and our resources and some folks as not. And we know that that shouldn't be the case. We know that these are public entities, but we explicitly spell it out under law in order to ensure that the folks we know that discrimination exists against will be protected regardless of who they are, because some people are discriminated against for who they are in relation to things that we should all have access to, regardless of the community we're a part of, or different kinds of status. So we know that, of course, in some of our shelters, many things are factoring into why people are being denied services, but all too often, people can be denied services because they are unhoused, because
I think
are.
in some of these cases, I follow what you're saying there. So for instance, a person saying, I don't have an address, I can imagine, I don't have an example, but I can imagine somebody working for a government entity saying, well, look, without an address, I don't know how to enter this in my system, whatever, you're gonna have to come back when you have an address. Okay, I can like figure that out. But I'm saying like movement on a sidewalk, we'd agree like every citizen, every person in the United States has an equal right to walk on a sidewalk. As a legal matter, I understand you're saying like, you could have a bad actor. But I'm saying in terms of what the law already protects for the citizens, we all have an equal right to move on a sidewalk right now, don't we?
So I feel as if I've already answered this question. Public spaces are supposed to be public spaces, but we know that in practice they are not. We know that in practice some people are denied access and entry regardless. So we put into law protections when we recognize that the discrimination and denial of services is happening regardless of what should be based on how we define something. Public spaces are open to everybody because we consider them public, but we are not protecting that access for the folks that are consistently and proven to be denied that access.
This is what I'm saying. Under current laws, if a police officer were to say to a person, you're walking on this sidewalk, but you're homeless, here's a ticket. We agreed like that's illegal, it's unconstitutional, it's a denial of equal protection. There's probably a federal lawsuit to be had because of that.
Yeah, it should not happen, but we also know that our local governments are coming up with their own solutions for how to address homelessness, or not address homelessness, but not wanting homelessness to be something that is a visible situation. So regardless,
that's where my question
yeah.
is. So like in this example of the moving on the sidewalk, are you intending to touch actions beyond movement on the sidewalk, like sleeping on the sidewalk?
No, and that is because this law is written so that folks who are unhoused, regardless of housing status, everybody has equal access to facilities. If you can't sleep on this, if you can't set up residence on a sidewalk, then nobody would be able to set up residence on a sidewalk. Because this one, unfortunately, to a certain extent, ideally we would always think about equity. This one talks about equality, and that's why I try to really drill home that we are only going so far as to say we need to practice what we preach and think about other people being impacted in the same way that we are. At the same time, we need to acknowledge what data says, what experience says, and know and acknowledge that kicking somebody who is sleeping off a sidewalk does not address homelessness. It shifts somebody's sleeping space to somewhere else. And so all we're doing is shifting people out of our sight until we can exercise that cognitive dissonance. So while this will bring us to a place of equal access, I am asking local governments to recognize there is nothing to support that hiding unhoused people actually helps unhoused people or actually ends homelessness for our local governments.
One last technical question, if I could, Mr. Chair. All right. And I think I mentioned this last week when we didn't have much time for questions, but the reasonable expectation of privacy in the individual's personal property to the same extent as personal property in a permanent residence. Mm-hmm. Can you help me understand that one? Because I can't imagine there being a way to say that for a person who doesn't have a home, their personal property is subject to a greater level of legal protection than a person who does have a home. I don't see how that could be constitutional. To say if you're a person who happens to not have a home, then your personal property in a public space is subject to a higher level of privacy than a person who has a home but also has personal property in a public space. So if two people are walking through a park, they both have every right to be there. Are we trying to create an elevated level of privacy for one person based on whether he or she has a home?
Yeah, so I appreciate that question because it's easy. I would not and could not walk up to you when you're sitting in a park and take your sweater. I couldn't take your lunch. I couldn't throw it away. I couldn't take it home with me. Why? Because it's yours. It doesn't matter if you are in your house or in the park. I can't take it. It's yours. You have a right to personal, private property, and so does anybody else who is out in our public spaces. And you're right. We can't say that somebody has more of a right than another person, but that's not what this says. This says that everybody has equal rights to private property and privacy of their information, which means stealing somebody's things or destroying somebody's things, regardless of whether it's at the movie theater or in the park or out of their house, is not okay. Now, I can guess, because the kind of questions you ask, and I appreciate them, that there may be more questions beyond that. Does that mean that in somebody being discriminated against based on housing status, or I'll translate that even more and say if somebody's belongings or private information is taken or shared without authorization because they are unhoused, that would be protected under this in a civil suit. But also, I would personally argue that our local governments really need to think about the fact that under legal definitions, there is also theft, there's also destruction of property happening. It is just the fact that we have decided that some folks don't have the same right to privacy and property that lets us justify that we will take people's belongings, in this case, everything they freaking own, and destroy it.
So in a civil suit, do you imagine the local governments being subject to punitive damages? That seems to be what the remedy section suggests.
Anybody who denies equal access, and I would say, so just as with so many other kinds of non-discrimination law, if you are responding in a humane way using best practices, if you are providing equal access and opportunity, you don't have to worry about being slapped with a lawsuit. Don't treat people like crap. You're not going to be sued.
Okay, we're going to move on to Rep. Stone.
Thank you, Mr. Chair. And I think I have an illustration that might help. So if I leave Meijer and I have a grocery bag in my hand with possessions that I've purchased and I'm on my way, I'm walking home, nobody's likely, it's rarely likely that someone's going to interrupt me and the possessions I own. However, someone who's unhoused, whose all their possessions may be in a grocery bag, but may be distinguishable, may have those taken, stripped of them, and thrown away and treated like garbage, when in fact that's their entire life possessions and shouldn't be treated any different than what I just bought at the grocery store.
Okay, I did have a few cards here that I wanted to read in. Supporting the bill and wishing to speak, Marcia Parrott Boyle. Are you here? Come up, Marcia.
Thank you. I am very much a citizen that's concerned about all peoples in my community, and being a citizen of this community of Lansing, I do think that equal rights, whether it's protecting where their right to be where they're at, be it in a park or be it outside of Jimmy John's on Washington Avenue, is very, very fundamental and should be considered as a necessity for sure. And as a professional safety officer, I just have to drop the thought with you folks that prevention, prevention, prevention is a good motto to keep in mind. And yes, one of the routes of homelessness is rent, as well as mental illness and a number of other routes that brings people to homelessness. And I hope that we can continue to do better as a society. Thank you.
Thank you, Marcia. We have William Walker wishing to speak. It doesn't say if you support or oppose, but I'm assuming you support.
I support.
Thanks, Mr. Walker.
I was taking time to listen to what was being said. The issue of personal property, I'd like to thank Representative Stone for opening the door for me. Let's say I'm homeless. I'm sleeping on a bench. I got my cart of personal property over here. The police come up. Does he know that's my personal property? No, he doesn't. Do I have any identification to prove that's my personal property? No, I do not. Is it out in public view? Yes, it is. Can I prove it's mine? No. He can take it. That's going to create the problem, because I'm going to be upset because that's all my personal property. And it goes beyond that. We'd have to review the Fourth Amendment, but personal property and the rights protecting personal property under the Fourth is based on a reasonable expectation of privacy. That's sitting over there in public view. It's not in my control. So therefore, do I have the right? Is it protected by the Constitution? That's a very serious question. The bill gives us that protection. We talked about the sleeping on the sidewalk. I live in the vicinity of the Avid Ministry. I watch them sleep in gazebos. I don't appreciate them sleeping over there, but I'm not going to put them out in the rain. Every woman, every man has the right to sleep somewhere. To me, I love the United States, and there's some basic rights, and I give them that right to sleep somewhere. So I don't say nothing about it. I spoke last time of the man sleeping by Rite Aid. Still haven't got the picture, but I do know others have seen it as well. These are things that we need to start addressing. I come in here today with a cowboy hat on. It's time to take this bull by the reins. We got to take this bull by the horn. He's a powerful bull. He's been around for a long time, and he is growing. The longer we allow it to grow, the harder it's going to be to take him down. But we got to start making these efforts. Civil damages, well, we all know we can make a lawsuit out of anything. Your dog barking, keeping me up at night, we can make a lawsuit out of anything. And I'm fully aware of that. But the problem is, as things stand now, there's too many gray areas. Let's start addressing some of these gray areas. But most importantly, let's start addressing our problem, the capital city's problem of the homelessness. I do not endorse by any means, and do I advocate anyone's right to sleep on the sidewalk. That would definitely offend me quite deeply. I report to a higher deity, and my basic concept is treat others the way I want to be treated. So I stand for that. Good day.
Thank you, William. And then the last one is Kyle Richard from Rennis Too Damn High. Is he here? I know we have people in another room, so I'll give him just a minute.
He's coming.
Okay. Thanks, Kyle. We'll have to keep it just to a couple minutes because we have more speakers on the next bill.
Yeah, I'll keep it brief.
Thank you.
Good morning. Housing is a human right. Housing is a human need. I spoke last week in favor of 4919. I'm still in favor of 4919. I took some time to review the letters from the opposition. Anyone that tells you this bill is dangerous or unnecessary or will somehow lead to encampments or turn us into California, which came up more than once, these folks fundamentally do not understand the issue at hand. You know what's dangerous? Being homeless. You know what leads to encampments? A system that validates the feelings of the lords of the land over the lives of the rest of us. Thank you.
Thank you. I appreciate your testimony, and thank you, Vice Chair Devendorf, for coming back up today. Just to backtrack a bit, and I apologize to the stakeholders who put in these cards on 4891. That was Andrew's bill. I didn't see these under my stack, but I'll just, none of them wish to speak, but in support was Heath Lowry from Michigan Coalition to End Sexual and Domestic Violence. Opposing the bill, Jim Kirsch, Property Management Association of Michigan, and John Lindley, Michigan Manufactured Housing Association. Thank you. Okay, next we're going to take testimony on 4878. This is Representative Ayash's bill. Rep. Ayash. Thanks, Floor Leader Ayash. Go ahead when you're ready.
Thank you, Mr. Chair, and dare I say, Mr. Mayor. Can't say that. I know I have to behave. My apologies. Good morning, members of the committee. Mr. Chair, thank you for the opportunity to have a discussion on what I believe is an incredibly important piece of legislation to address the concerns of if we got folks that are able to pay rent or afford housing, then that should be the principal and narrow focus on whether or not we allow them the opportunity to lease or rent that space. So House Bill 4878 is the Fair Chance Access to Housing Act, which would focus the scope of the use of criminal background checks when someone is applying for rental housing. And this would apply to public, affordable, and private properties. This is incredibly needed because we know that one of the number one deterrents of reducing crime and one of the number one deterrents of recidivism is ensuring that people have access to stable housing. So let's talk about what this legislation would mean for the nearly 3 million Michiganders who would be impacted by this legislation. 10 million folks in our state, 3 million people have something to the tune of a criminal background. So if we think about that, we are essentially saying 30% of our population should not have access to housing because they went through the criminal justice process, they were sentenced according to the law, they served their time, and now they have now finished and atoned for that mistake that they made according to our criminal justice system. We are still saying that beyond that part of your life, you will continue to be punished for something of the past. So this legislation would address the problem by saying only the relevant concerns of somebody, and I'll give you an example. Say you have a history of arson. You're somebody who burns stuff down. That is a legitimate thing to flag if you are going to rent in an apartment unit or in a house. Say, for example, you have a history of sexual abuse and sexual misconduct. That is, or you're on the registry, that is a legitimate concern if you are in a multi-unit housing development. But if somebody 10, 15 years ago stole something and has a petty theft on their record, what does that have to do with their ability to pay rent if they have shown stable employment, if they have shown all the necessary paperwork to prove to the landlord that I can pay rent and I can pay it on time and I can pay it for the duration of the lease? Then that is the thing that we should be focusing on. So we're going to have a couple folks testify today, but I just wanted to go over a couple things with this legislation. So first, the housing provider would screen an applicant on standard criteria: their income, their rental history, do they have dogs or cats, we charge them that extra fee, so on and so forth. During that initial step, a housing provider cannot consider a person's conviction history. If the housing provider decides to move forward with a qualified applicant, so this is just for the initial application. I'm going to walk it through. I don't know if many folks on the committee are renters, so I just want to walk through this process with you all. They will then be offered they will then be issued a conditional offer of tenancy. So you submit an application, your numbers look good, you have a dog, we're okay with your dog, so on and so forth. We're going to give you an initial offer. After that, the housing provider may choose to run a criminal background check. And the housing provider can run a background check and only consider the following points: any felony conviction within the last 365 days. So any conviction within that past year is something that would be relevant for this conversation. Any convictions for arson or human trafficking at any point, and whether the applicant is required to register on the sex offender registry. So if the background check reveals any of these offenses, the housing provider must conduct an individualized assessment, then looking at the case and saying what exactly happened so we can better understand the story behind this particular applicant. That means that they have to consider the various factors to the offense, including the nature and its severity, the age of the applicant at the time of the offense. If somebody did something when they were 17 years old and now they're 24, and we know that, or 30 or 40, they've clearly made a mistake when they were younger, that's something that should be considered. And whether the offense was connected to a rental property in which the applicant previously lived. So at that point, the applicant could provide a documentation of rehab efforts. So once that happens, and they then feel that their rights were violated under the Fair Chance Access to Housing Act, which is this bill, they can then file a complaint with the Attorney General's office, and the act will be enforced under Michigan's Consumer Protection Act. So this is legislation, for the record, that's already moving towards a direction where our country is headed. The HUD department, the federal HUD department, came out with guidance in 2016 and again in 2022, laying out limited protections for people with conviction histories under the Federal Fair Housing Act. And in Michigan, several communities, Jackson, Ann Arbor, Detroit, and Kalamazoo, have all passed local fair chance housing ordinances since 2019. So this is not a novel idea, this is not a new idea, but it is an important idea to make sure that we can address some of the concerns of people not having access to housing. In New Jersey, they enacted a similar statewide fair chance housing law, which has been successful in curbing housing discrimination against people with conviction histories. This legislation would be modeled after that particular law. So this is our chance in the Midwest to lead in this area in the same way we were able to do so with our historic clean slate legislation a couple terms ago. This would be the strongest protection in the country, and it would make Michigan a model practice for the rest of the U.S. And with that, I'm going to pass it along to our several presenters, Mr. Chair, at your discretion to further go into it, and then we can get into questions after. Thank you.
Who's with you today?
From the Variance Studio.
Hi, I'm Dr. Nilufer Tabor from the Vera Institute of Justice.
Thank you, Doctor. Did you want to take a moment to speak?
Yes, please. Thank you. Good morning. Chairman Coleman, Vice Chair Dievendorf, members of the subcommittee. My name, as I mentioned, is Dr. Nilufer Tabor. An Associate Director for Research for the Opening Doors Initiative at the Vera Institute of Justice. Vera works to end mass incarceration, protect immigrants' rights, provide dignity for people behind bars, and to build safe, thriving communities. My qualifications include a Master of Public Policy and Administration in Urban and Social Policy with a focus on housing, a Master of Public Health in Epidemiology with a focus on mental health and substance abuse, both from Columbia University, and a PhD in health systems from Johns Hopkins School of Public Health. At Vera, I conduct research on the housing needs and barriers for people with conviction histories. Today, I'll testify in support of Bill 4878, the Michigan Fair Chance Access to Housing Act. I'm going to talk a little bit about the research on housing stability and public safety and address some of the concerns that have been raised regarding this policy, including its effect on public safety, housing providers, and the affordable housing crisis. So this bill will provide an opportunity for people with a conviction history to have a fair chance at housing. Michigan deserves both safety and justice, and this bill will deliver both. Existing research tells us that there is a cyclical relationship between incarceration and homelessness, with people who are incarcerated being 10 times more likely to experience homelessness than the general public, and people who are homeless being more likely to be arrested, convicted, and incarcerated than the general public. A 2021 review looking at 18 different studies from around the world found that in every single study, housing was associated with decreased criminal activity. And in short, this bill will make sure that Michigan's communities are safer by allowing people with conviction histories to have that stability that comes with housing. Despite these many benefits, housing providers often shut out people with conviction histories due to a variety of concerns. So these are that renters with conviction histories will provide a safety concern to other tenants, that landlords will face legal liabilities, or that it'll have a negative effect on the workload or the safety of their tenant-facing staff. But these concerns, they're sincerely held. They generally originate from a desire to be a good landlord, a good employer, and a good community member, but they are totally without foundation. So regarding safety, there is no evidence that policies that exclude people with conviction histories make housing complexes or communities safer, or that people with conviction histories have different tenancy outcomes than other residents who don't have that same history. So in fact, research finds that the majority of people who have a conviction never have a second one in their lifetime. A criminal background check therefore provides information about that person at the time of their conviction, but it doesn't tell us anything about who they are today or what progress they may have made in their life, gains in education, employment, or stability. As for concerns about liability, the bill explicitly states that landlords will not be held liable if they rent to someone with a conviction history who then commits a crime. And then finally, for concerns about staff well-being. In our research and our work with landlords who have changed their policies to be more inclusive of people with conviction histories, those landlords have not found that their policy changes required a large injection of new resources or new training for staff. They did not report any change in the safety of their communities, either for tenants or for tenant-facing staff. So despite the very understandable concerns to the contrary, all of the evidence indicates that housing for people with conviction histories helps communities to remain safe and to thrive. Another often voiced concern that we hear is about the cost of housing. So Michigan, like many parts of the country, is facing an affordable housing crisis. And concerns have been raised that this bill will increase the demand for the limited supply of housing, leading to raises in rents. So these concerns also have no basis. So first, it's unlikely that formerly incarcerated people will flood the private rental market. Most people who have a conviction had low incomes before their conviction and have even lower incomes afterward. IRS data shows that for 5 years following release from incarceration, at least 90% of people have incomes that are less than $25,000 a year, meaning people simply don't have the incomes to make large-scale changes in the demand for housing in the private market. Second, and more importantly, housing experts agree that to address the affordable housing crisis, all components of the housing market need to be brought to bear. This bill will ensure that private, affordable, and public housing can be available for people with conviction histories. And this expansion should reduce the stress and the overburdening on other components of the housing system, especially transitional housing and shelter systems. I'd like to close with a story. So Vera is conducting research with a housing provider who has several hundred units and who changed their criminal background check policy to be more inclusive of people with a conviction history. As part of this research, we conducted interviews with tenants who did not have conviction histories. One man who we spoke to was upset about this policy, what he thought was an upcoming change in policy. He was concerned for his own safety, his wife's safety, the safety of his neighbors, his community members. What he did not know was that this policy had been put into effect 5 years previously, and he had been a tenant only for 4. In other words, the policy had been in effect the entire time that he had been a resident, and he had not noticed anything about his living situation that would have made him concerned. And when asked, he said that he felt safe in his home and in his neighborhood. And indeed, his concern was actually about losing that safety, not realizing that he already had both safety and also neighbors with conviction histories. So the evidence and the research is clear that for the safety and the justice of all Michiganders, this legislature should pass the Fair Chance Access to Housing Act. Thank you.
Thank you, Doctor. We have a question from Rep. Fink.
Thank you. So I don't think that it makes any sense to be concerned about flooding the already short rental market with additional applications. I mean, that's, people have to live someplace. I don't even see why anybody would bring that up as a concern. What I do wonder about, and actually if we could kind of take a quick step back on this, in section, how'd you start these numbers, Representative Ayash? Section 5, subsection 2. I think this is actually maybe something that we've kind of glided past here. A landlord must issue a conditional offer after screening the application. If after screening the application, the landlord determines the applicant satisfies all the application criteria under subsection 1, which is a list of things that can be considered but explicitly excludes criminal records. A requirement that a landlord issue an offer beyond the already, the already extant prohibition about discrimination on various bases. But that in and of itself is a pretty significant policy change, isn't it? I mean, we don't have anything like that today, where if somebody comes and applies, a landlord, if the person essentially basically qualifies, a landlord must then issue an offer, do we?
Representative, I can't speak to that particular piece on whether or not it applies in other aspects, but I will say this. If somebody applies for a vacant apartment that you are renting, for example, and they meet all the qualifications, I'm hard pressed to understand why they would not offer that person the opportunity.
But you agree that legally today, as long as it's not for a reason that violates one of our anti-discrimination laws, race or sex or gender or religion or something like that, the person could, the landlord doesn't have to issue the offer. Whereas if we adopt this legislation, they would have to.
Well, if they meet the qualifications, again, I'm not understanding why they would not offer it. So if I came to you and I meet every single standard that you need for me to rent that property, I show you that I have the money, I show you that I have the income, I show you that I have the security deposit, XYZ, the credit score, all that, and you then still want the opportunity to say, actually, I don't want to rent to you. So on what basis would you be saying that?
Well, this is what I'm saying is as long as it's not for an impermissible basis, it could be for any reason. What if I'm superstitious and a crow flew by or a black cat walked by? I'm not saying it would make sense, Representative. I'm just saying right now, the landlord is not bound to issue an offer. But under this legislation, they would be. And that's irrespective of the issue of the criminal background. I mean, that is in and of itself a pretty significant policy change. Isn't it?
Again, I'm happy to look into that, but I would just offer this. I'm not in the business of discussing what doesn't make sense as an application of this law. I mean, to your point, if you don't have a legitimate reason to reject someone's rent application, why are you rejecting the rent application?
Well,
it's really that.
I think that does get to the more fundamental question here, which is, are there ways to address the problem? Which I think I share the basic sense that there's a danger of landlords acting irrationally in rejecting a person's application because they have a criminal history.
Sure.
All right. So I share that concern. I mean, I think that could be a real problem in any given case. Are there ways to address that don't directly go at the freedom to contract? Because what we're doing here is we're saying if you decide to rent, then we're going to impose a pretty significant layer of regulation on your freedom to rent the way you want to. And
so what does that mean, right? Can we say the quiet part out loud? When we say the way you want to, what are we talking about?
to be able to say, if you have a felony conviction for something other than one of your listed crimes that's 2 years old, I'm sorry, I just don't want to deal with that. Right now, a landlord could say that, right? And so what we're saying in this legislation is, well, no more. The landlord could no longer say,
Correct.
a 2-year-old conviction is a disqualifier for me.
That's literally the point of the law, yes.
Yes, so we're saying the quiet part out loud then. So what I'm saying is, that's a direct limitation on the freedom to contract that a person currently holds.
Okay.
Is there a way to address the issue that doesn't directly restrict the freedom to contract? Because
I'm gonna have to give the other reps some more time.
Mr. Chair, if I may, Representative Fink,
Briefly.
I deep respect to how you sort of take seriously all the legislation that comes before you. I'm happy to have a conversation about this. If it's not in this exchange of the committee hearing right now, we sit a seat and a half away on the House floor. So I'm happy to continue this conversation and address that concern, and certainly not trying to ignore that question, but I'm just saying that the whole point of the law is, you can't use someone's irrelevant criminal history if they have one, if they've already served their time and did what they had to do under our criminal justice system. And if we want to talk about the gaps in our justice system, that's another conversation. But
Okay,
if
we're going to have to move on to Rep Stone. I'm
I look
sorry.
forward
For
to
the
it.
sake of time, I got to move on.
My
'Cause
apologies,
We got a
Mr.
lot of
Chair.
reps that want to speak, so thank you, gentlemen.
Thank you, Mr. Chair. Thank you for this legislation. I think the data that you've shared has bared, what are the problems, what's the problem we're trying to solve, and how do we prevent it? And I think it's better to deal with data when we have it and let that guide our decision making. My one question that I'm not quite clear on is, how are people who are currently in the parole system addressed by this legislation?
So this is based on conviction history rather than current community supervision status.
Just for clarification, once they have left incarceration, that's the completion.
So a person's conviction, so it's the time since the conviction. If the conviction has occurred within the last year, the last 365 days, that is the sort of what starts the clock for this look-back
Gotcha.
period.
Okay, thank you.
Minority Vice Chair Aragona.
Thank you, Mr. Chair, and thanks, guys, for being here. I appreciate you bringing up the subject. As I said last week, when I was a kid, I had somebody living. Our family had a number of different people living with us. One of which, over a year, who had been convicted of manslaughter. He just needed somewhere to live, right? So I understand the sentiment, but Rep. Ayash, I'm a little confused as to how this works. So, an application comes in, you can't consider criminal history at all. They check all the boxes that you need. Then you can consider criminal history, but only within a certain confine of, I believe, federal law. I think human trafficking was on there. And then I believe it's on page 6. It's only saying that arson or human trafficking or anything that has been adjudicated within the past year can be considered for denial. So the way I'm reading that, there's plenty of felonies out there. If somebody had 366 days ago been adjudicated for child abuse, and I'm an apartment owner and I don't want to rent to them because I know I got a bunch of kids running around my apartment building, doesn't this say that I have to rent to them?
So, can I ask a question to that? What does that crime have to do with their ability to pay rent?
Representative, my question is, if I'm a landlord, I got 4 units and 3 of them are filled with families and kids. And the last one, some guy wants to rent that over a year ago, he was convicted, just over a year ago, 366 days ago, he was convicted of abusing multiple children. I can't turn him down. I have to say, under this law, if this were to become law, I have to say, you, sir, even though you abused children with just over a year ago, you can go live by all these families. How are those families going to feel?
How would they know that he punched kids?
I said abuse.
Yeah, or abused children. So if we're talking about abuse, could be sexual in nature,
Could be
correct?
sexual in nature.
Okay, so if someone is accused of sexually has to register this. If someone abuses a child, more often than not, it's a sexual in nature. I'm hard
I
pressed.
wouldn't even go there, but if you want to go there, that's fine.
But that's what the data shows. I mean, no one's getting arrested for running around slapping random children, right? Oftentimes, they're sexually abusing a minor, right? So in that case, they are registered in the sex offender list, and that would be disclosed as well.
Okay.
Even if it happened
fully answer my question.
No,
because
it does, because if it happened 4 years
I'm
ago,
going
it's
after
still
one felony, but there's plenty of felonies out there besides arson, human trafficking.
Right.
That I would think that there's plenty of families that don't want somebody convicted of a plethora of felonies, including child abuse. But it goes beyond that.
So
that they
if-
wouldn't want them living next to them.
So if the nature of the
and
crime,
if the landlord says, "Hey, I really don't think these families that I currently rent and pay rent to me and are very, very good tenants,
Sure.
I think they'd feel uncomfortable. I think I need to deny you."
So, Rep. Aragona, here's the thing. If somebody committed a crime that is as severe as you're claiming, my assumption is they serve time in our incarceration system. No one is going to get a conviction and be released for an egregious crime.
And they would never plead down?
And if you want to discuss the gaps in our criminal justice system, we can have that conversation elsewhere. But
Shouldn't
I'm
we do
simply
that
talking
first?
about, again, I'm not going to say people deserve to be homeless because our criminal justice system has gaps. That's a different conversation. And respectfully, it's a straw man argument. I'm simply saying the following. If someone's crime was egregious enough that they had spent time in jail and a judge or a jury, which is what our criminal justice system is intended to do, sentences this person for that crime and they served the time, why are we going to further punish that person if our system said this is the amount of time you have to spend in prison, this is the amount of time you have to spend in jail, this is the outcome of the crime you committed, this is the punishment for that crime.
Okay, I got
So if
Mr. Chairman, I got one more
I
question.
need
if
you
that's
guys to
okay.
wrap this up quick.
I got one more question separate from that on Section 5, and it kind of goes to my colleague, Representative Fink's question. There's a number of criteria that will now go into the application that you will consider. Income eligibility, rental history check, credit score check, right? My question is, if I'm a landlord and I have one open unit, and I advertise I have one open unit, and I get 4 applicants, how do I offer a conditional offer to all of them when there's only one unit and they all qualify?
Whoever pays up first.
Okay, we're going to move on to
That's how it
Vice
works.
Chair Devendorf.
They pay up first?
Vice Chair Devendorf. Thank you.
I mean, I'm not going to dictate the free market, Representative, respectfully.
I would hope not.
If there's 4 people that can pay rent, I guess pick the richest person. I don't know.
Gentlemen,
But doesn't this open it up to more litigation?
I'm gonna address some of these questions. So-
gentlemen, we got to move on. We still have multiple speakers today, and we just don't have enough time. So,
My apologies,
yeah,
Mr.
Thank
Chair.
you.
So, yeah, right. So any non-discrimination policy helps to set standards for what can be included under the right to contract. So right to contract is going to exist until or unless somebody is doing something wrong in discriminating. So you still can create a contract, but regardless of anything, as with so many laws, you're still not allowed to break the law or do something that discriminates against another person. We shouldn't be writing our contracts in order to discriminate. Some of the policy that is being referred to is not this. It's another kind of policy. There's a kind of policy called first come, first served that asks that whoever is the first applicant to a rental property that meets the posted criteria for what the landlord offers needs to be offered that tenancy. that leaves it up to the landlord to make clear, this is what the structure is like, these are the community standards, this is what we're looking for. The first person who meets that qualification, regardless of any of our arbitrary feelings about them, needs to qualify for that apartment. If there's a waiting list because of limited numbers of units, then there becomes a line that you choose from, and it still can be first come, first served. Right now, that is not under Michigan law. It's not something we have to debate. Right now, today, we're talking about discrimination and making sure that offenses that no longer represent whether somebody is safe or not, making sure that they do not get in the way of providing shelter. When providing shelter, we know it does make such an impact for reducing recidivism and helping for our communities to be safer, period.
Representative Andrews.
Thank you, Chair. I want to say, of course, I think right to contract is an incredibly important issue, but as we know, it's very difficult to prove discrimination often, even though the protections exist. I mean, unless the landlord is foolish enough to say, I don't want to rent to you because you're black or something very similar to that, they just can simply not rent to the person, and it's very difficult to prove. These court cases are very hard to settle. So I do think there is some value in what you're proposing here around, limiting the decision-making process, particularly as it pertains to the background checks, because if you don't, there's a myriad excuses that can be given that, wouldn't otherwise violate the rule. What I'm curious about, and maybe Vera Institute, you guys can speak to this a little bit, is when it comes to the current law and when people with criminal backgrounds are applying, do you have data you could provide to us on how often the person's race or gender ends up maybe unintentionally being tied to why they're denied alongside their criminal background? AKA, do we see black offenders, male offenders, female offenders, whatever the case may be, more often denied based on their criminal background than not?
Yeah, so that research hasn't been done in Michigan, but we have seen research in places as diverse as Seattle, New Orleans, and Washington, D.C. that have done what's called matched pairs testing, where they have sent people who have similar background on all aspects except for race, sent to a housing provider to see who gets the apartment. What they find is that if both applicants have a conviction history, that conviction history is more often excused among the white applicant than it is among the black applicant, such that a conviction history serves as a proxy for racial discrimination.
Okay, we're going to move on to Representative Grant.
Mr. Chair, if I may, we have several other folks that could provide some more insight and testimony, and then at your discretion, if they can present first, and then we take follow-up questions.
We just got a couple more reps that want to speak. If you can keep it brief, Rep Grant, go ahead.
I'm okay with
Okay.
waiting.
Okay, Rep Cerniglu, you, and then DeBoyer.
How are you, Rep?
Great.
So, why do we maintain criminal history records? What's the purpose behind them?
That's a good question. I don't have the answer to that.
Okay. So, we do have some parameters in this bill that spell out what we can ask and what we can request with regard to our determination. One of them, I think, is financial history. I mean, I think it's an obvious answer, but what is the purpose behind asking on that financial history?
Yeah.
There's a reason, right?
Sure.
And I would assume that reason is to make a determination, previous behavior, future potential, right?
Yeah.
And my question would be is why do we as the government believe that we can tell a landlord what they believe to be a risk? Because we frankly are telling them that it's okay to consider a financial risk, but it's not okay to consider a criminal risk.
Because here's the problem,
And
Representative.
we're actually ranking the financial above the potential harm to fellow or other tenants. Would that not be true? I mean,
So if I were, I'm going to use an analogy for a second. If I wanted to go into a dealership and buy an F-150, I would be confused if the car dealer said, "Show me your motorcycle license," because that has no bearing on whether or not I can drive an F-150. So similarly, if someone is seeking to rent a place to live, the transaction in nature is strictly on the finances. can you at the end or beginning of every month pay for the contract you are about to sign into? So if you are able to prove that you are going to pay for that house or that apartment or that condo, that you will be liable for any damages to that property, and that you'll follow all the guidelines that that landlord sets, then those are the things that should matter. If I decided to shoplift 10 years ago, that has no bearing on whether or not I can pay rent if all my financial records can attest and my job history can attest that I can secure stable employment and finances to then pay for that rent. So the suggestion that once someone, and I want to go back to this point, the data doesn't lie. We know that people who have one conviction history, one history of conviction, likely do not commit a second crime after that. But the interesting piece is, it goes up when they don't have access to housing and jobs. So if we're actually trying to address the problem of crime, which I think you would appreciate, then we need to look at how we can avoid putting people back in situations to then continue to commit a crime. Now, in those situations, one would have to look at the things that perhaps are unnatural for a person. If somebody stole once, or even to the extent that Rep. Aragona said, and they served their time, that's a conversation. Now, if someone's a sex offender, if someone is an arsonist, those are legitimate concerns. And we're not discounting the fact that there are crimes that should be looked at. There are things. If someone is a serial rapist, they absolutely should not be living in a unit with multiple single men and women, for example.
Can I just ask you, and it's to the true test of what the language could create for us. And it does go to the Section 5 too, where the landlord must issue a conditional offer. And can I just ask you a scenario? The reason that I do have an issue with that exact piece is because it's taking total discretion away from the landlord. For example, in a town that you may live in, you may have knowledge of an individual who may not have been convicted. Great example would be perhaps someone who dated your daughter who was abusive to your daughter, and you may have an upstairs rental, and that individual applies for that rental. They may not have any criminal conviction, but you may have intimate detail of behavior, and now I'm going to be a must on renting to that individual when perhaps my daughter lives in the home with me as well. Still, that's why there is some concern on that must language. It really takes a lot of reasonable, logical, and an appropriate discretion away from a landlord.
Well, in this example, you cited, Representative, if I had my daughter that lived with me in an upstairs unit and her ex-boyfriend wanted to live with me.
Well, rent from you.
Rent from me. I would have my daughter file a PPO or a restraining order, and the solution could be solved, right? So, and I would be hard pressed to believe that there are situations where my daughter's ex-boyfriend wants to rent from her father. So
Okay. We're gonna, thank you, representatives. We're gonna move on to some speakers now, since we have some waiting. Sheriff Chris Swanson, Genesee County Sheriff, thank you for coming today. If you want to come up.
First of all, I think the public should see the good work that's done behind the scenes. As an observer, you don't get enough credit for all that you do to get a bill through and all the negotiation. So I just want to say thank you on behalf of a constituent, even those that aren't representing my area. A lot of good points. I come to you as simply a perspective. I didn't craft the bill. I had no input in the bill, but I bring a perspective because this is where good government gets done. This is where the debates come to common ground on any issue. So I heard a lot of things that I think are worthy of additional conversations for everybody here, including those behind me. I come from a perspective that checks all those boxes. When I first got hired as a sheriff's deputy in 1993, I remember getting trained to toss a cell. And we go into the cell, and the senior deputy says, "Now don't forget, this is their house." In a cell where two people live, 6 by 8, you have a top bunk, bottom bunk, and they have their face cloth here, their shower shoes under the bed, their bin is turned up to dim the lights. And I knew that if you took care of somebody's cell, even by tossing it, there's a level of respect there. I saw other deputies that treated it with no regard, tossed it, everything's out outside, and next thing you know, we're fighting. we can all agree that stable housing, no matter where you are, is a key to nice sleep, good family, and the reduction of crime. There is a direct connect, I guarantee it. Because in the jail, I saw it firsthand as a 20-year-old that didn't get taught this at Grand Blanc High School, that if you take care of people inside the jail cells, they won't be a problem with you outside when on the floor. I actually rented and also owned houses. I don't really like using the word landlord. I think it's kind of a class situation, lord over somebody. I was a property owner, 1612 Maryland. This was on the east side of Flint. It was the first house I bought even before I got married. And Dennis, who was a single dad with his daughter, I remember he called me up. He's like, my heater's not working. I'm not mechanical, but I went over there and I had to go underneath to change this thermocouple. Bugs and nasty, and I'm changing it. And I knew when I was under there, I said, he wants one thing and I want another thing. He wants heat and I want him to take care of my place. So even as somebody who owned property, that not only in Maryland, on Dakota, I had an AFC home, had 5 people that I was able to give beautiful housing for. Those were all tenants with families. I owned my house, and as I raised my family like you did, there's one thing I never had to worry about my whole life, even growing up, is a place to sleep and be safe. I think if there's one thing, Mr. Chair, and everybody who sponsored this bill, we are all on the same path to say there is nothing better than stable housing for all of us. Nobody woke up this morning thinking, man, I wonder where I'm going to sleep tonight. But I can tell you, lifetime, in the Genesee County Jail, there's 560 inmates that are in jail right now. Of those that we have data on, I track it through the Flint Housing Commission, the Flint Health Coalition, and our data at the booking process, 40% have stable housing. 40, about 220 of them, have a place to go, an address, whether they own or rent. That means that 6 out of 10 inmates that I have are couch surfing. At 12:01, they get out. They have no place to go. And it's not the only solution to reduce crime. So is treatment of mental health, addiction treatment, as well as education, which is why we're doing in the jail, treating people like educated students so they can go get a trade and never come back. As the sheriff, my goal is to keep people safe, crush evil. That's why we've arrested 215 sexual predators, and we've got a 100% conviction rate to human trafficking. I get that. I see the path. People that abuse animals and torture and beat them to death, they shouldn't be allowed to own more pets and do it again. And I know that there's no bill that you can possibly craft that is going to fit every scenario. But I would encourage you as a tenant, as a landowner, as well as somebody who owns his own home, that you are so close to getting something that has never been done, and that is stable housing for returning citizens. Now, I'm almost done. Just for the sake of being transparent, you're talking to a guy who employs full-time 2 returning citizens, Percy Glover, John L. Allen. Percy did 12 years for murder, John L. did 29 for murder. I've known them since they were 93. We started in the jail. They went and did their time rep, they came back, and they are full-time sheriff's deputies, community engagement officers. They don't look like me. They don't worship like me. I'm so glad any of those times when I was getting a mortgage or trying to get a rent that they didn't rent to me or give me a mortgage because I was white, or not give it to me because I was white, or where I worship, or who I live with. If there's one thing that we actually have to really have a hand in, it is the most basic needs. How do we give everybody a fair shot regardless of the path, with the idea that we do have to have some discretion? There has to be autonomy on both sides. And I think you guys in this room, or you folks here in this room, are so close to doing it right. I will tell you selfishly, if you can help fix the stable housing issue, not only here in the state, but be an example across the country, you're going to reduce crime, and you're going to reduce victims, and you're going to save families rep about living in areas that they need to kind of claw out to. And we need our tenants. We need our property owners. We need our massive apartment complexes. But there's a thing that we can do, and I speak to 3 different crowds, and the first one is you. You are in the driver's seat, not just because of a party, because true legislative geniuses like you, people that have committed to stick their hand up and say, vote for me, I'm going to represent. You have the collective interest of the whole state. I get it. I, as the executive leader of a sheriff's office, have a responsibility to protect people. We're all in the same mindset as government. We have to do our job to protect, serve, and unify. But to the landowners out there, they got to provide good housing, safe housing. And there's a lot to that. Don't just provide slums because that's all they can afford. Provide good housing and give people the opportunity. That's why I'm educating folks in the jail. I don't ask them what they did. I don't send letters to judges. I don't advocate for lesser sentences. But while you're here, you're going to be better so you never come back. But the third thing, and it represents the people that are behind me and hear my voice, is the returning citizens that I advocate because I believe they too want to change their life. I couldn't have full-time convicted murderers with me if they didn't realize the burden to make this work is on them. So for anybody who's a returning citizen that has been given an opportunity, maybe because of this committee that it pushes on to become law, that they respect the process and treat land property with respect, pay their bills, be a good neighbor, and make it so it's easier for the next person. That's what you're owed as a legislative leader. I think all three parties and all stakeholders have to be involved. You're so close. I'm glad we're talking about it. As a sheriff, this is very important to not only myself but other law enforcement officials out there. I will end with I have my keychains. You do too. I got the county keys, my 181,000-mile Tahoe, my badge from the county, and my house key. I know it's going to let me into the Swanson house, and I don't know what it would be like if I didn't have a place like that. So the reality of it, we're all on the same page. You're so close. Stay the course. You can get this done.
Thank you, Sheriff Swanson. And for the record, Sheriff Swanson put in a card of support. We're going to have just a couple more speakers. We're going to make it very brief because the members need to get to session, and we're going to stop in about 5 minutes. Jessica Henry and William Walker from Nation Outside, if you can come up, and you got to keep it pretty short here because we're running out of time. And they put in cards supporting the bill.
Good morning, Mr. Chairman, Majority Vice Chair, Minority Vice Chair, and honorable members of the committee. Thank you for giving us the opportunity to testify before you today. Did you want to go first? Okay. My name is Jessica Henry, and I'm here to ask the committee to support House Bill 4878. I would like to share with you my continual housing struggles through my personal story. I was raised by a single mother who had 3 children before the age of 18. We moved 5 times before I turned 10 years old. At the age of 8, I ran away from home due to physical, emotional, and psychological abuse suffered at the hands of my mother. I was placed in juvenile detention centers multiple times before the state figured out it was the abuse I was running away from. I was placed in a youth home and eventually foster care, which lasted almost 3 years before custody was returned to my mother. Within months, she suffered a nervous breakdown, and I moved once again to be cared for by my absent father. I dropped out of school and became pregnant at the age of 15. After staying in an abusive relationship for the first 5 years of my child's life, I, like my own mom, became a single mother. I became financially unstable and needed money to pay the rent. At the age of 20, I cashed fraudulent payroll checks and served some time in jail for uttering and publishing. Upon my release, I found it difficult to obtain a job and, more importantly, housing to care for my daughter. My criminal history was the reason for denials and rejections. I couldn't afford to pay my restitution, so I returned to jail 7 more times before I served my first sentence with the MDOC for absconding my probation. During my 14-month incarceration in prison, I was able to obtain my GED at the age of 29. Once I was released, I returned home to the very same struggles with housing. This time, I enrolled in college, but was unsuccessful due to the instability of my living situation. I was sleeping on friends' couches, and I was even homeless at one point. Living this way, I had developed some unhealthy habits and spiraled into drug addiction. I returned to prison 18 months after my release on a 5-year and 7 months unarmed robbery charge. I had come to a point where the barriers I was facing had become so discouraging, I had just about given up. I do know that while incarcerated, I had time to reflect upon my life choices and knew it was time to make a change in my mindset and behaviors. I was offered to participate in the Second Chance Pell Grant program and earned 3 associate's degrees while I was incarcerated. My education was my turning point. I graduated with a 3.96 GPA, high honors, and Phi Theta Kappa. I chose to relocate once I was released and went to a transitional home in Jackson, Michigan. SOAR, which stands for She Overcomes and Rises, is a place of healing where I was able to gain stability, reunite with my family, and maintain a healthy lifestyle.
Thank you for your testimony. I got to move on to the next speaker. We're only got about a minute, so sorry to rush you, but we had a lot to get through. I wanted to prioritize the members' questions today, and we'll see about maybe having you come back if we run out of time. But go ahead, please
Hi, everybody. I'm Jordan Else. I am here to be the landlord voice of support for this. I, too, don't like the word landlord. I prefer property owner, but we'll go with landlord because I think that that is an important thing, to realize our power and that we can make decisions that can support people's recovery or that can contribute to recidivism. I have a speech, but I'm going to really shorten it as we're asked to, but I want to speak to some of your questions because I hear you and I understand the concern about landlords being concerned about this. So we are judging risk, right? We're deciding whether we prioritize the risk to our society and returning citizens, or we prioritize risk to ourselves as landlords. For years, we've been prioritizing the landlord voice. It's where the money is, it's where the power is, it's where the lobby is. And we have people here that are asking us for a simple change, that we prioritize the risk to our society, that we help people get back into society, and that we can say we can make our society safer. I really appreciate Sheriff Swanson being here. I think we all agree that discrimination in housing is a problem. I've heard everyone on all sides agree to that. And really, criminal background checks have just allowed us to codedly discriminate. If we're going to say that we know that the justice system disproportionately impacts black and brown citizens, we know that it's going to disproportionately impact them on housing, and that it's going to allow us basically a legal way to discriminate. My husband and I don't do background checks, criminal background checks. We didn't before the ordinance. Our family's been in business for 55 years, and we have never once had a bad outcome from not doing them. As you know, Ann Arbor passed the ordinance in 2021, and I don't know of any situation where harm has come to either landlord or tenants as a result of that. So I think that's probably my minute, but I thank you guys for listening, and I'm available if there's any questions.
Thanks for your testimony.
Yeah, thank you.
Jordan Else from Messenger.
That's me.
Oh, that was you. I'm sorry.
We
Okay, appreciate
swapped
that.
William. If William has a minute, we
Thanks for
could-
putting in the card of support. William Lawrence from Rent is Too Damn High. Okay, appreciate it. Thanks for your card of support. Megan Brooks from Avalon Housing put in wishes to speak and supports the bill. Megan, are you here? Yeah, I'm here. Okay, go ahead, Megan. We just have one more speaker after you.
I will also try to keep this as quick as possible. My name is Megan Brooks. I am the outreach team lead at Avalon Housing in Ann Arbor, Michigan, and I'm also 1 out of 3 million in the state of Michigan living with a criminal history. So I'm going to tell you a little bit about what Avalon Housing does in Ann Arbor and how we support folks that do have criminal history and criminal backgrounds. So Avalon Housing provides affordable and supportive housing to people in 29 properties throughout Washtenaw County, and we've been a landlord since 1992. As a housing provider, we balance the needs of everyone, including those of the renter, other neighbors, the broader community, as well as Avalon as a landlord. And from our experience, providing housing from people with criminal records poses no threat to the safety of people in the community. We don't maintain traditional wait lists for our units, so we receive tenant referrals from our Housing Access of Washtenaw County, which is our first step of the coordinated entry system in Ann Arbor. And we therefore evaluate our tenants differently than private landlords do. So, for example, our tenants can't have an annual income that is higher than 60% of the area median income. We learn about whether or not they have some form of rental assistance that can contribute towards their monthly rental payments. And when we look at a prospective tenant's prior background, so mental health, physical disabilities, substance use disorders, and the prior criminal background, it's in order to ensure that they have the best chance to stay stably housed. So this policy would incorporate individualized reviews, and this is a great way to get to know the tenant. Each person is more than what their record shows. I am more than what my record has shown. So landlords who only consider income sources or criminal background screenings may be losing the opportunity to have great tenants. And if I do say so myself, I think I'm a pretty good tenant for my landlord. So based on this practice, Avalon has not had any more issues with tenants who do have criminal records than those without criminal backgrounds. And our experience thus far has shown that tenants with records still pay their rent on time, take care of their units, and don't pose a safety threat to the community or the surrounding neighborhoods in our community. And I believe that it is our duty as landlords to provide housing for all who qualify. And this bill will ensure the qualified tenants will get the housing that they need and honestly what they deserve.
Thank you. We appreciate it. And then our very last speaker today, Gabriel Biber, Haven House. I got the cards here, and I believe you already, did you speak earlier, sir? Okay, we'll see if we can have you, but Gabriel, go ahead.
All right, thank you, Chair and Committee. Just want to strongly support this bill. I know you're all aware that there are fair housing protections, federal fair housing protections, so I think some of the question has been, why do we need this fair chance housing? We need it for the reasons, the questions posed by the representatives, because we're not actually seeing in practice fair housing happening. We're seeing proxy discrimination. And so I work at a homeless shelter. We serve families. We have 7 families that we can serve in our shelter. It's just a few minutes down the road. When these families are looking for housing here in our community, they're being denied for irrelevant felony or misdemeanor convictions in the past. These are the things, and I really, truly hope you'll take into consideration the testimony of the sheriff, those here with lived experience of prior convictions. This is absolutely something that is not in any way a threat to housing or to the housed community, but is absolutely a necessity to serve folks that need equal access to housing. And the protections that exist are not robust and sufficient enough, as has been previously testified about. Thank you.
Thank you. We have William Lawrence, who wanted to speak and supports the bill. I'm sorry, William. I have a Lawrence here on my card. Okay, but for the sake of time, we're going to have to stop for the day. I appreciate everybody coming. We'll see if we can open it up for more testimony in the following week or two. Seeing no absent members, Representative Minority Vice Chair Gona moves to excuse absent members. Seeing no objection, the motion prevails by unanimous consent. Therefore, being no more business before the committee will stand adjourned. Thank you, everybody.